Welcome, everyone. Is this working? Yes? I'm Jack Goldsmith, and welcome to the Herbert Vaughan Academic Program. We only have 55 minutes, so I'm going to be very brief in introducing the program. Mr. Vaughan, who endowed this program, was a 1948 graduate of the law school who practiced law with Hale and Dorr, which is now Wilmer Hale, for 47 years. He asked that this statement be read at the beginning of each of these events. In my judgment, the Constitution of the United States is the greatest practical achievement of political science. It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you be guided and inspired by their genius as you meet the challenges of the present day. And now I'm going to very briefly introduce our speakers. And as I said, I'm going to keep the bios short in the interest of time. Today's Vaughan lecturer is Melissa Moschella, and the title of her lecture is How Broad and Strong Are Parental Rights Under Pierce. Professor Moschella is professor of the practice and philosophy at the University of Notre Dame's McGrath Institute for Church Life. Her work spans the field of ethics, political philosophy, and law, and her areas of expertise include natural law theory, biomedical ethics, and the family. She's the author of many scholarly and popular articles, as well as 2 books. The first one is To Whom Do Children Belong? Parental Rights, Civic Education, and Children's Autonomy, and the forthcoming Ethics, Politics, and Natural Law, Principles for Human Flourishing. The first commenter will be Dailey, who is the Ellen Ash Peters Professor of Law and Associate Dean for Faculty Development and Intellectual Life at the University of Connecticut. Anne is at the far right. I'm sorry. And Melissa is right here. Anne's teaching and research focus on family law, children and the law, and law and psychology. She's the author of Law and the Unconscious, a psychoanalytic perspective, as well as numerous scholarly articles in several fields. Last but not least is Erika Bachiochi in the middle, who's a fellow at the Ethics and Public Policy Center, right? Yeah, I left that out of my notes. And a senior fellow at the Abigail Adams Institute. She works at the intersection of constitutional law, political theory, women's history, and Catholic social teaching. Erika is the author of The Rights of Women, Reclaiming a Lost Vision, as well as numerous scholarly and popular works. And with that, I will introduce Melissa, and thank you very much.
Well, thank you so much. It's a real honor to be here, to have been invited to give this lecture, and certainly a delight to be back at my alma mater and walk down memory lane here on the blustery but still pretty fall days. So let me just go ahead and dive right in here. Pierce v. Society of Sisters, following Meyer v. Nebraska, unequivocally affirmed that parents have the right to direct the upbringing and education of children under their control. At issue in Pierce, the centenary of which we celebrate in spring 2025, was an Oregon law requiring all children to attend public schools. The Supreme Court found the law unconstitutional, stating famously, quote, "The fundamental theory of liberty, upon which all governments in this union repose, excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only," unquote. Yet despite the Pierce Court's lofty rhetoric about parental rights in education, subsequent court decisions have interpreted Pierce quite narrowly and weakly. The next major case regarding parental rights in education to be taken by the Supreme Court is Wisconsin v. Yoder, in which Amish parents sought an exemption from the state's compulsory education law so that they could educate them at home in the Amish way of life after the 8th grade. Although the court ruled in favor of the Amish, Justice White's concurrence offered a narrow interpretation of Pierce, indicating that, quote, "In Pierce, the court held simply that a state may not preempt the educational process by requiring children to attend public schools," unquote. Just 1 year later, in Norwood v. Harrison, the court approvingly quoted Justice White's narrow reading of Pierce and relied on this reading to emphasize the limited scope of the decision, which merely, quote, affirmed the right of private schools to exist and to operate, unquote. In 1976, the Supreme Court in Runyon adopted Norwood's limited view of Pierce, also quoting White's concurrence in Yoder. Now, Runyon was the last case regarding parental rights in education to be argued before the Supreme Court. Subsequent disputes related to this issue have been decided by lower courts, which, as we'll see, have consistently adopted this narrow understanding of Pierce. Both the Supreme Court and the lower court's interpretations of Pierce have often been not only narrow, but also weak, in the sense that they have often failed to apply strict scrutiny in parental rights cases. Although the Supreme Court in Troxel v. Granville, which was a dispute about third-party visitation, referred to parental rights as fundamental, it didn't apply strict scrutiny or declare strict scrutiny to be the appropriate standard of review in parental rights cases. And so, following the Supreme Court's signals, federal circuit courts have likewise interpreted Pierce narrowly and weakly. You can see a list of some of the most prominent of these circuit court cases dealing with this issue on the slide. The common thread in them is that parents claim the right to be informed of in advance and/or be able to exempt their children from certain aspects of the public school curriculum. And in all cases, the parents lost, in part due to the court's narrow and weak interpretations of Pierce. Now, I don't have time to go over all these cases in detail, but by way of example, and just to spice things up a bit, let me walk you through Brown v. Hot, Sexy, and Safer. Now, in this case, students at Chelmsford High School and their parents brought a complaint against Hot, Sexy, and Safer Productions and the Chelmsford School Committee for requiring the students to participate in a sexually explicit assembly. According to the plaintiffs, whose allegations were accepted as true by the court, the assembly was full of, quote, profane, lewd, and lascivious language, unquote, and included sexually explicit conduct, such as a simulation of masturbation, inviting a male student to lick a condom on stage, and inviting a female student to take the condom and pull it over the male student's head. The plaintiffs alleged, among other things, that the defendants violated their right to direct their children's education, and claimed on the basis of Meyer and Pierce that this is a fundamental right that the state can only infringe for the sake of a compelling interest narrowly tailored to that interest. The First Circuit, however, questioned whether parental rights are truly fundamental, and argued further that even if they are, quote, the plaintiffs have failed to demonstrate an intrusion of constitutional magnitude upon this right, unquote. The basis for this argument was a narrow reading of Meyer and Pierce as implying only that the state cannot require all children to attend public school. But according to the First Circuit, once parents do choose to send their child to a public school, they have no constitutional rights to determine what the child is taught or exposed to within the school. The bottom line in all these cases is perhaps most pithily expressed by the Ninth Circuit in Fields v. Palmdale. The Meyer-Pierce right does not extend beyond the schoolhouse door. Now, I should note that the opinion was later amended and this line was replaced with something a little more nuanced, but the line nonetheless still captures the upshot of the decision. Indeed, despite the amendment, the Ninth Circuit itself quoted the original line, not the amended version, in a subsequent case regarding Hindu parents who complained that the school's curriculum discriminated against their religion. So is it true that parents' constitutional rights to direct their children's education end at the schoolhouse door? More broadly, are these narrow and weak readings of Pierce correct? I will argue that they are not. To make my argument, I'll first examine the Pierce opinion itself, then look at the Meyer decision upon which Pierce was based. And finally, because I think that Meyer and Pierce declared the common law understanding of parental rights to be part of the liberty protected by the 14th Amendment's Due Process Clause, the last section of my talk will illustrate that common law view of parental rights by looking at pre-Meyer state Supreme Court decisions that granted parents on the basis of common law the right to exempt their children from some aspects of the public school curriculum. For those interested in more specific details about the common law view, you can also find those in an article just published in the Texas Review of Law and Politics that I wrote. So let's turn to the Pierce opinion. First, what standard of review is being used in Pierce? In the interest of time, I'm going to go through this very quickly, but the basic idea is this. Pierce claims to be using a rational basis standard, but this is prior to the development of the tiers of scrutiny doctrine. And the law at issue in Pierce does have a rational relationship to one or more legitimate state interests, such as the assimilation of immigrants. So the fact that it's declared unconstitutional gives some evidence that what we would today call strict scrutiny is being used. Further evidence for this is found in the fact that both the Ninth Circuit and the Supreme Court shift the burden of proof to the state and say that the state fails to show that the law is necessary, not just reasonably related, to the state's interest. So I think we see that the main elements of strict scrutiny are present in the reasoning, a shift in the burden of proof plus the least restrictive means test. So moving on to the scope of parents' educational rights under Pierce. First, I want to consider the implications of what are perhaps the most famous lines in the opinion. The fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Now, it could be argued that the clause, by forcing them to accept instruction from public teachers only, limits the scope of the right protected by Pierce, leaving us with the narrow interpretation that has dominated in subsequent decisions. But this narrow interpretation seems incompatible with those same justices' own interpretation of their ruling just 2 years later in Farrington, which held on the basis of Pierce and Meyer that a law undermining the autonomy of private schools through extensive government regulation was also an unconstitutional violation of parental rights under the 14th Amendment. The next sentence of the Pierce opinion seems to enunciate why the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children. This power is excluded from the competence of government because parents, not the state, have primary authority in this matter. Parents, not the state, are the ones who bring children into the world, and so parents, by nature, by virtue of their unique relationship to their children, have responsibility for their children and corresponding authority to carry out their child-rearing duties. Those familiar with the common law view will see clear echoes of Blackstone and Kent here. And although I could go on at length about the foundational philosophical case for parental rights, I'll restrain myself for now and just focus on the constitutional arguments. But if anybody wants to hear more about that in the Q&A, I would be more than happy to oblige. The text of the Pierce opinion also provides more explicit guidance regarding the scope and limits of the state's educational authority. The decision acknowledges, quote, the power of the state reasonably to regulate all schools. And then after the semicolon, it goes on to indicate what that scope of reasonable regulation is. That is, what the state can look for and require when inspecting, supervising, and examining schools, pupils, and teachers. And it lists 4 things. 1, that all children of proper age attend some school. 2, that teachers be of good moral character. 3, that certain studies plainly essential to good citizenship be taught. And 4, that nothing be taught which is manifestly inimical to the public welfare. The implication, it seems, is that coercive state action, not clearly falling into one of these categories, would be constitutionally questionable as beyond the proper competence of the state, because it would be intruding into matters that belong to the proper competence of parents. Moreover, this interpretation of Pierce's implications regarding the scope and limits of the state's educational authority sheds further light on the opinion's claim that the act in question has no reasonable relation to some purpose within the competency of the state. For as already noted, the act does have a reasonable relation to many state interests. But arguably, it nonetheless goes beyond those 4 categories of things that Pierce lists as within the state's competence, and is arguably, for that reason, outside the competency of the state. Now, Pierce, of course, relies explicitly on Meyer in its reasoning, and so to more fully understand the scope of parental rights under Pierce, we need to look at the Meyer opinion. In Meyer, the Supreme Court overturned a law forbidding the teaching of foreign languages in schools prior to the 9th grade. Although the ruling is based most explicitly on the right of teachers to pursue an honest calling, much of the opinion focuses on parental rights. In addition to highlighting the right to marry, establish a home, and bring up children, as among those privileges long recognized at common law that the court considers to be protected by the 14th Amendment, the court also states, echoing the language of the common law tradition, that it is the natural duty of the parent to give his children education suitable to their station in life. The opinion then emphasizes how our form of government contrasts with Plato's famous proposal for communal child-rearing in the Republic, and with the ancient Spartan practice of taking children away from their parents to be educated by state officials. The court comments that the theories underlying these proposals are, quote, wholly different from those upon which our institutions rest, unquote, and that such policies would do, quote, violence to both the letter and spirit of the Constitution, unquote. In other words, the Meyer Court emphasizes the inherent connection between respect for parental rights on the one hand and limited government on the other hand. Indeed, this connection seems obvious, for there is no surer way for would-be dictators to shape society in accordance with their own ideological vision than to have control over the education of all children. It's also noteworthy that Meyer, like Pierce, implicitly applies what today we would call strict scrutiny. For the court recognizes that the law does have a rational relationship to a legitimate end, but nonetheless holds that, quote, the means adopted exceed the limitations on the state. Why? These means are beyond the competency of the state because they're ultimately based on the same statist view of child-rearing, exemplified in more extreme form by the communal education schemes in Plato's Republic and ancient Sparta, schemes which are inimical to limited government. And so for the Meyer Court and the Pierce Court that built upon Meyer, the purposes that are within the competency of the state in the educational realm are limited by the primacy of parents' educational authority. And the state exceeds its competency when it intrudes upon that authority in ways that are not truly necessary for the state's end of ensuring that all children receive an education sufficient to be law-abiding, productive citizens. Hence, Pierce's quite narrow list of the sorts of regulations that it's within the competency of the state to enact, such as requiring all children to be educated to a certain minimum level, requiring studies plainly essential to good citizenship, and forbidding studies manifestly inimical to it. This analysis of Meyer, and by extension of Pierce, according to which the primacy of parents' educational authority effectively limits coercive state action in the educational arena to actions justifiable under what today we would call strict scrutiny, is further supported by examining state court decisions in the preceding half-century. These decisions give us important insight into the common law understanding of parental rights that Meyer and Pierce proclaimed to be part of the liberty guaranteed by the 14th Amendment. So let's look at these pre-Meyer state Supreme Court decisions briefly. From the mid-19th to the early 20th century, there was a string of 8 cases brought by parents who sought to exempt their children from aspects of the public school curriculum while still retaining the ability to avail their children of a free public school education. The parents prevailed in 7 out of 8 such cases, several of which were cited and quoted in the brief for the Society of Sisters in the Pierce case. In these cases, the courts argued that the common law understanding of parents as possessing primary educational authority implies that parents have the right to direct the education of their children, even within the public schools, as long as the exercise of this right doesn't undermine the ability of the schools to fulfill their purpose. So here I'll focus on just one of these cases, School Board District number 18 v. Thompson, an Oklahoma case that is representative of and refers to the other cases from the other states. Because the court bases its decision largely on the common law understanding of parental authority over children as prior to the authority of the state, it's a helpful illustration of this common law view. and of how that common law view applies concretely when parental authority and state authority come into conflict. The issue in Thompson is that the parents did not want their children to take the singing lessons in the public school, and the children were expelled from the school for refusing to attend the singing class. The parents sued, wishing their children to be reinstated in the schools but not forced to take the singing classes, and the Oklahoma Supreme Court decided in favor of the parents. The court's argument begins by making reference to the common law view that parents are the ones who are by nature responsible for the maintenance, protection, and education of their children. These duties, says the court, were imposed upon principles of natural law and affection laid upon them not only by nature herself, but by their own proper act of bringing them into the world. The court insisted that this principle stands even after compulsory education laws have been enacted. The court also argued, echoing Blackstone and Kent, that the state should defer to parents' educational judgments because the parent has greater interest in the child's welfare and greater knowledge of the child's capacities. In the course of its argument, the court made very strong statements about the primacy of parental authority vis-a-vis the state. Under our form of government and at common law, the court wrote, the home is considered the keystone of the governmental structure. In this empire, parents rule supreme during the minority of their children. Although the court acknowledged the right of schools to make reasonable rules and regulations, the court nonetheless concluded that for the reasons just mentioned, the parent has a right to make a reasonable selection from the prescribed course of study for his child to pursue, and this selection must be respected by the school authorities, as the right of the parent in that regard is superior to that of the school officers and teachers, as long as this does not interfere with the efficiency or discipline of the schools. So how do these cases help us to determine the proper interpretation of Meyer and Pierce? First, Thompson, along with the 6 other similar cases, provides strong evidence that under the common law view, parental rights do extend beyond the schoolhouse door and include at least parents' right to exempt their children from certain classes, as long as this is not incompatible with the efficiency of the schools. If, as I've argued, Meyer and by extension Pierce declared parents' common law rights to be included within the liberty guaranteed by the 14th Amendment, this means that the narrow reading of Pierce as merely guaranteeing the right to send one's child to a private school at one's own expense is incorrect. Second, these cases also call into question the weak reading of Pierce as requiring only a rational basis test for parental rights cases. For just as in Meyer and Pierce themselves, an examination of Thompson and of the 6 other similar cases already mentioned indicates that a heightened standard of review was implicitly being applied in these cases. But in the interest of time, I'm going to skip past the details there and move straight to the conclusion. Analyzing Pierce in light of its historical context, and especially in light of Meyer and the pre-Meyer state Supreme Court cases reflecting the common law understanding of parental rights that Meyer declared to be protected by the 14th Amendment, suggests that the narrow and weak interpretation of Pierce that has dominated to date is historically inaccurate. On the contrary, a careful analysis of both Pierce itself and of the relevant historical background should lead us to conclude that parents' constitutional rights to direct their children's education are both broad and strong, and that the state's authority in this area is correspondingly circumscribed, limited, as Pierce says, to requiring studies plainly essential to good citizenship and forbidding those manifestly inimical to it, and to setting up schools to ensure that all children have access to an education that will enable them to be responsible citizens. And so, on this view, federal district court cases like Mozart, Brown, and Fields were wrongly decided, and these cases erred in failing to apply strict scrutiny. Now, given the proliferation of current disputes between parents and school districts, I think the time is ripe to correct these misinterpretations of Pierce. Correcting these misinterpretations will help make it possible for all parents, including parents of limited financial means, to fully exercise their natural and constitutional right to direct the education of their children. Now, one might worry that this will open the floodgates of parental rights litigation, but I think such worries are exaggerated. The high costs of litigation are a strong disincentive, and once parents win one or two victories in court, schools will take notice and be more accommodating at the outset. One might then object that this would be unworkable for schools, but this too seems implausible, given the already common practice of opt-outs for sex ed classes, along with things like IEPs and special programs for gifted or special needs students. Further, on my view, a full vindication of parental rights in education would also require ending the public school's monopoly on public educational funding through programs that give all parents genuine school choice. And this, in turn, would lessen the need for exemptions and accommodations in public schools by giving parents who object to aspects of the curriculum a real opportunity for exit. But my constitutional case for school choice, which I develop in another article, relies not only on Pierce, but on First Amendment jurisprudence, so we'll save that for another day. Finally, it's worth remembering that strong parental rights protections ultimately redound to the well-being of children. Because, as the common law tradition emphasized, and as the US Supreme Court has affirmed, parents are much more likely than the state to know what is best for their children and to be motivated to promote their children's welfare. Vindicating parental rights would therefore be beneficial not only to parents themselves, but also, and primarily, to their children. Thank you. Should I just close the computer?
Hello. It's wonderful to be here. Thank you, Melissa, for that fascinating paper, wonderful paper, and I'm honored to be here to give some comments on it. I'm especially delighted that Melissa is drawing our attention to the historical importance of Pierce, and I really like the paper and the value that it's contributing in terms of our focusing in on Pierce's place in the history of constitutional law. But I'm going to spend my few moments explaining why I think Melissa's reading of the case may be just a bit too simple. She argues, as you know, she just told us that the Supreme Court and lower courts have been misinterpreting Pierce all these years by viewing its holding as narrower than it actually was. As she says, the prevailing account of Pierce is incorrect. But I read Pierce as being a much more complicated decision. Justice McReynolds' opinion is not easy to decipher. In fact, I would say that the correct reading of Pierce is that it is a profoundly ambiguous opinion, obscure on the question of the relationship between parents and the state, and impossible to pin down as offering either a broad or narrow view of parental rights. But while Pierce equivocates on the nature and scope of parental rights, this ambiguity itself provides a window onto the complex history of the family's place in constitutional law. I believe Pierce is less a case about establishing broad parental rights and more a case grappling with changing ideas about democratic citizenship and who has ultimate responsibility for ensuring that the lifeblood of a democracy, its children, will acquire the values and skills necessary for democratic self-government. So my basic argument is this. McReynolds' opinion in Pierce straddles two views of the relationship between families and the state. On the one hand, a traditional view of parental authority as continuous with state power, a view that posited a deep connection between family patriarchy and the Republican polity. And on the other hand, an emerging liberal view of the family as separate from and even opposed to the state. It is this tension between what I'll call a Republican view of parental authority and a liberal view of parental rights that produces the ambiguity in Pierce's opinion. So let me describe the ways in which Pierce gives voice to the common law's older Republican view of the family. Melissa is right that the common law conferred broad rights on fathers to the custody of children. But a father's custodial right was not rooted in a notion of the family as a private sphere separate and apart from the state. To the contrary, family relationships were defined and regulated by the state. These were status relationships. The early common law rested on a view of the family as a patriarchal institution with husbands at the head, wielding authority over their wives, children, and household servants. The father's status as the natural head of the household reflected a deep continuity between the family and the polity, treating fathers as sovereigns in the home, a role viewed as essential to stabilizing and sustaining the republic. The common law not only set the status hierarchy of family members, but it also assigned duties, and among those were fathers' educational duties to their children. These duties were prescribed by law. They weren't left up to the individual fathers to decide how best to raise their children. Instead, they were duties aimed at ensuring children became responsible, virtuous Republican citizens. But then starting in the late 19th and early 20th centuries, a liberal view of parental authority began to emerge in law, along with changing ideas about the relationship between families and the state. Industrialization saw men going outside the family to work, women assuming authority within the home, child labor laws and compulsory education laws were passed, shifting the primary responsibility for educating children to the state. The view of the family as a private sphere, as a haven in a heartless world, began to supplant the older view of family and state as one integrated system. In family law, we call this the rise of separate spheres ideology. In this new liberal world, home would be a place of private moral training, and public school the place for equipping children with the values and skills of democratic citizenship. In Pierce, McReynolds recognized the state's power to compel parents to send their children to school. At the same time, however, he also affirmed that parents still had a role to play in ensuring the health of the democratic nation. The threat of communism from abroad was prompting fears about state indoctrination of young minds, giving parents the role of protecting against the tyranny of Plato's Republic. But McReynolds was not affirming the idea that anything goes in the home. While he famously proclaimed that the child is not the mere creature of the state, the child was not the mere creature of the parents either. McReynolds grandly proclaimed that those who nurture the child and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. In Wisconsin against Yoder, the court would clarify that the additional obligations referred to in Pierce included instilling elements of good citizenship. Pierce captures a moment in time where the court was struggling to reconcile a traditional Republican vision of parents' proper role in the raising of virtuous citizens with newer liberal ideas about parents' freedom to inculcate morals and values potentially at odds with liberal democratic ideals. This tension in Pierce would soon erupt into a full-fledged battle over state requirements that school children recite the Pledge of Allegiance. In West Virginia against Barnett, the court would side with parents, famously stating that they are educating the young for citizenship as reason for scrupulous protection of constitutional freedoms of the individual, if we are not to strangle the free mind at its source. Parents could be forced to send their children to school, but not forced to endure their children's conscription into pledging allegiance to the country over God. But the following year, Prince against Massachusetts, the court would come out on the other side of the debate, holding that, quote, parents may be free to become martyrs themselves, but it does not follow that they are free to make martyrs of their children before they have reached the age of full and legal discretion when they can make that choice for themselves. Pierce thus did not provide a clear answer to the question of whether the Constitution protects broad or narrow parental rights, but instead opened an ongoing constitutional debate over how a modern pluralistic democracy inculcates democratic values and skills in future generations, without also extinguishing the rights to freedom of thought and conscience that sustain democratic self-government. The tension is now viewed as a paradox at the heart of the secular liberal project itself. Modern liberal thinkers define a liberal democratic education in terms of what we might call habits of mind: tolerance, reasoned deliberation, equal respect. Public schools with their relatively diverse student bodies, are understood to provide the opportunity for these habits of mind to develop. That is the thrust of the court's opinion in Tinker, recognizing the classroom as a marketplace of ideas. But a vision of democratic socialization limited to tolerance, reason, and respect isn't enough. We need a theory of democratic education that goes beyond classroom learning to recognize the fundamental role that parents play in raising democratic citizens. I have argued that parents not only have rights, but they have duties. Duties to care for their children, to provide them with a family environment that cultivates a sense of belonging and attachment to a shared moral universe, but also duties to ensure their children have the opportunity to develop the tools for accepting or rejecting that given moral universe as their own. The Pierce decision thus provides the opportunity for us to formulate a vision of the shared role of parents and state in raising democratic citizens. Doing so means articulating exactly how parents provide for children's developmental needs and democratic flourishing. Parents, importantly, initiate children into a way of life, by which I mean they give children an initial moral framework and deep attachments to people, to ideas, beliefs. But a modern pluralistic liberal democracy must also insist that parents provide children with the opportunity to develop the capacities of tolerance, reason, and respect that will allow them to embrace their given worldview as their own, or if they so choose, to pursue a different way of life. So Pierce, in my mind, opens our eyes to the inescapably normative task of socializing children to become citizens of our democracy, a task that requires that we articulate both an ideal of the secular liberal virtues, so to speak, as well as a vision of the shared role of parents and state in cultivating them. We know this task isn't an easy one. It can't be done by simple resort to some mythical public-private divide or to neutral principles. We will disagree, perhaps vehemently, over the normative content of that ideal. The task is messy and imperfect. Some children will be forced to live lives they would not have chosen. And some parents will feel that their way of life has been damaged or even destroyed. The task requires that we face unpleasant truths. Truths about law's weakness, its ultimate inability to ensure democracy's survival, as well as about law's strength, its ultimate power to insist, through violence if necessary, upon children's right to become democratic citizens. So I'm grateful to Melissa for the opportunity to revisit Pierce's foundational, if ambiguous, place in this ongoing constitutional struggle with democracy's core existential challenge.
Thank you, that was wonderful. I'm really glad to be here as we sort of consider this really fine lecture on parental rights and duties in Pierce and Meyer. I think Professor Moschella has smartly and really carefully reread these early 20th century cases in their own historical and legal context, just as these new claims today arise concerning parents' rights to educate their children. So I'm grateful to Professor Goldsmith for inviting the good professor to bring these old cases to our attention again, and for inviting me and the dean to offer short comments. Now, despite the notable absence of a Supreme Court case concerning parental rights in education for the last half century, and in Melissa's assessment, the narrow and weak application of Pierce and Meyer in lower courts ever since, students of modern constitutional law are not entirely unfamiliar with these case names, Pierce versus Society of Sisters and Meyer v. Nebraska. And so as we discuss the proper interpretation and application of these cases in the educational context, I just want to issue a kind of reminder of where we've all heard the names of these cases before, but without the benefit of the rich history uncovered for us today. I think it's good to fill the picture out, especially for the students here, of the key role these two cases have played
in modern constitutional law. For even as the court was interpreting Pierce and Meyer narrowly with regard to the rights parents have to educate their children and rendering these cases far weaker than the professor shows was warranted, these very same cases at the very same time were interpreted with great breadth and strength to serve as key precedents for perhaps more greatly favored rights. Pierce and Meyer, after all, were both cited as strong precedent in what we now call the personal liberty cases, starting with Griswold v. Connecticut, the Supreme Court decision that, of course, struck down the last remaining state statute prohibiting the use of contraceptives in 1965. Griswold notably adhered to the principle of Pierce and Meyer, which the Griswold court read with other cases as constitutionally protecting in the marital couple a fundamental zone of privacy. And then on this marital privacy turned individual liberty foundation, Roe v. Wade and Planned Parenthood versus Casey would themselves eventually include Pierce and Meyer in a long string of citations that gave shape to substantive due process in this arena. Now, there were academics and conservative dissenters who didn't quite see all these cases fitting so neatly together. But regardless of whether they do or did in fact fit in that area of law, a question well beyond the scope of our topic today, my point here is that Pierce and Meyer, while sidelined in the realm of parental rights and education, were not at all sidelined in modern constitutional law. They were just remade in the image of modern constitutional law. In fact, how the court treated and employed Pierce and Meyer as having them stand for a kind of broad and abstract principle of family and then eventually individual autonomy can help us better understand, I think, these distinctive eras of constitutional law, especially now that Melissa and really Ann too has unpacked for us with such care how the court of an earlier era understood constitutional decision-making vis-a-vis the family. So what I'm getting at is that crafting the modern abstract principle of family and then really individual privacy and autonomy as substantive due process is not the same thing as saying, as Melissa has said, that Pierce and Meyer themselves affirmed or acknowledged as part of 14th Amendment liberty the common law understanding of parents' concrete rights and duties. Note here my emphasis on modern abstract liberty as a protection for individual autonomy to do what one will, as distinctive from common law liberty to carry out concrete and particular duties, with the 14th Amendment giving constitutional protection to do so. Now, this certainly speaks to the problem of levels of generality and specificity involved in determining the kind of liberty protected by the 14th Amendment, but it is also to say more than that. It is to say that something really fundamental shifted between when Pierce and Meyer were decided and then when they were employed by the court 4 decades later. Anne has given us one sense of what that was. I think I'm going to give a bit of a different. There's another too, not unconnected substantive or philosophical change revealed by studying Pierce and Meyer as closely as Melissa has done. And that is the way, and this is kind of underscoring a lot of what she was saying, the way in which the court in those different eras understood the powers of the state vis-a-vis the individual and the family. As Melissa has shown, the modern way we tend to adjudicate parents' rights vis-a-vis schools is where parents need affirmative exemption from the state's authority to educate children. So the state enjoys this kind of prior authority from which a sliver of parental rights is carved out. Parents' individual autonomy, we might say, is protected to direct their children's education as they will, up to a point. And it is they who have to give an account of how that autonomy has been infringed by the state. A zone then, in this kind of modern view of family, privacy, or individual autonomy up and against the mass of state power. Finding the right balance between these clashing powers, or the will of the autonomous individual, parent, and the will of the governing majority, is the work of modern constitutional law. But I think Melissa reveals so well today that this view of the state vis-a-vis the individual would be really foreign to the jurists who crafted Pierce and Meyer. Parents in this earlier world are not conceived of as competing for and seeking to kind of carve out an exemption of the educational authority that resides in the state. Rather, to underscore her main point, parents enjoy a prior authority to educate their children from which flows the state's own authority to educate children. This is why schools, until very recently, were of course considered in loco parentis, in the place of parents. The power of the state and then the power of the parents then are not competing in a battle of these kind of autonomous wills, properly understood. Rather, the authority the state enjoys is entailed by the authority vested in the parents. In the Pierce-Meyer account, the parents' liberty to direct the upbringing and education of children exists, as she explains, by nature of the parenting role. She says parents are the ones who bring their children into the world and so are naturally responsible for and therefore have paternal but also maternal authority to carry out their paternal and maternal duties. And notice well from your own experience as parents or indeed as children, the parental duties that entail this authority and so correlative rights that are vested in parents are not at all abstract, but are concrete acts in favor of particular children. And this is the very nature of common law rights and duties. They spring forth from real patterns, fact patterns in the real world, with the principles drawn from them deeply informed by and necessarily tethered to these concrete and particular experiences and circumstances. The common law, we can say, comes up from below, from the duties we naturally owe one another. And we see this most plainly in parents' duties of care to their children. A constitution informed by the stored wisdom of the common law, as ours once really was, would do the same. But when we imagine, as kind of good moderns, the bodies existing in the legal world as the individual and the state and maybe the market, this can kind of worry us. What about parents who neglect their children, who don't educate them or educate them badly? But the older idea is that a whole set of obligations, rights, and authority exist prior to state laws enforcing parental duties to nurture and educate their children. In fact, in this older view, state law governing the family is giving black law or positive law recognition to these older to those prior or natural obligations, rights, and authority. And then the state is vested with the delegated or subsidiary in loco parentis authority to assist parents as they carry out their duties that are properly theirs, and then to step in when parental authority has been grossly ill-managed, or to generally assure, as we've heard, the law-abidingness and productivity of citizens, while ever recognizing that properly parental obligations go beyond these democratic liberal norms to perhaps religious, moral obligations, etc. And so as we learn, I think, from rereading Pierce and Meyer, this older way of thinking, and I think I would really send you all to read those cases themselves, we could suggest a very different set of legal questions that emerge in the educational realm. And I'm just going to make those more explicit, and Melissa's really already said them somewhat. It would not concern kind of this sliver of exemption that parents have vis-a-vis state power, but rather whether state educational institutions are properly carrying out their delegated authority in service of parents. The state in Pierce's account is entrusted with the power to reasonably regulate and inspect schools to ensure, as we heard, this good moral character and patriotic disposition of teachers, that what is taught is plainly essential to good citizenship and not inimical to public welfare. This is then to suggest that we interrogate not the parent's assertion of rights, but the state's execution of power, and ask whether it is acting in harmony with the source from which it comes. Melissa's astute rereading also suggests that there exists in our own legal tradition a way to think deeply about constitutional rights in the realm of marriage, family, children, and even sexuality, perhaps, that is not beholden to kind of liberal abstractions of autonomy and self-determination. It's a way of thinking, as the common law did, that is rather grounded in embodied, concrete, and particular responsibilities to concrete and particular others as they exist in our day, post-19th Amendment, post-common law coverture, consortium, etc. Protecting such liberties would then be understood not as expressive or individualistic. Protecting such liberties would provide the stable, just, and peaceable conditions for individuals to carry out their distinctive and respective responsibilities to one another. Thanks.
Thank you all. That was a terrific talk and exchange. Do you want to make a few brief
Very brief,
reactions?
yeah.
Great. Can you do it from there?
I can do it from here. Yeah. So just briefly, I mean, first, thank you very much. Those were both really excellent and thought-provoking comments. To Anne's comments, I would just say that I completely agree that parents have duties, not just rights. And in fact, I think the duties are prior to and are the basis of the rights. As Erika mentioned, in noting that Pierce and Meyer were relied upon in all these personal liberty cases, Griswold and then Roe and so on. But in fact, the rights being protected by Pierce are quite different. They're not autonomy rights. They're not the right to define your own version of existence and so on and so forth. They're rights to fulfill natural obligations, the natural obligations of parents to care for the children that they bring into the world. And those obligations imply decision-making authority because children are not capable of making decisions on their own behalf. So I do think the duties are prior. And I would also agree with Anne that there is a shared role of parents and the state in preparing children for citizenship. It's clearly an important and legitimate state end to ensure that all children receive an education that enables them to be law-abiding, productive citizens. But I don't think that the educational authority of parents and the state are on the same plane. Right? I think Erika put it nicely. The role of the state is subsidiary, secondary to, and aimed primarily at assisting parents in fulfilling what is primarily their duty. And even when you look at common law said, yes, the state can enforce the duties that parents have by nature. Parents have these duties by nature and the state can enforce them, but the state isn't making those duties up. The state can regulate the family, but it's not making it up. It's not creating it. So I'll just leave it at that. I could go on, but those are just a few points that I wanted to highlight.
Thank you. Questions? Martha?
I actually...
Wait for the microphone, please. And we're short on time, so please,
Yes.
if everyone could keep their questions short.
I actually come from the opposite end on Pierce and Meyer and thought maybe you were going to talk about how they were overemphasized, which is what I talk about in my classes. It seems to me they're Lochner cases, and I'm sympathetic with your thing about parents being able to exempt students from certain things, like certainly singing or acting in a sexually explicit play. But Meyer is about parents being able to force subjects on the schools. Maybe it was right on the merits, but I think when you talk about exemption, you're taking the easy cases. We also have cases of where parents and school boards are trying to force creationism into the schools and taking away Darwinism. We also have the Pico case, another Supreme Court case, where the parents pressured the school board and to remove from the school libraries about 15 different books, all written by Black authors. This was a school board in Louisiana, I believe. But there is that sometimes parents overstep their means, and I think that I agree it's a parental state balance, but I think there's a real danger of overemphasizing parental rights.
I mean, that's a good question. I think to your first point about these being Lochner era cases, they are. I think that's unfortunate, but I think that if there is any due process right that is a legitimate due process right, I think this would be it in terms of deep-seatedness in history and tradition and the centrality to the very nature of limited government. But I also think that if you don't like rooting it in due process, I think it could also arguably be rooted in the privileges or immunities clause, or even in the overall structure of the Constitution, right? I mean, that parental rights are to me almost akin to something like the presumption of innocence, right? It's not in the Constitution, but you can't make sense of any other constitutional guarantees of fair trial and due process and things like that unless you assume that presumption of innocence, right? I think parental rights are something like that. It's just presumed that there's this institution of the family with its own internal sphere of authority that's prior to the state that needs to be respected by the state. On your point about parents sometimes going too far, I mean, I'm not sure, I mean, I wouldn't necessarily agree with what the parents want the schools to teach in those cases, but if the public schools are democratic institutions, and if they're supposed to be serving parents and fulfilling the parents' educational responsibilities, then it doesn't seem odd to me that parents would want to shape what is being taught in their local public schools. In fact, that seems quite fitting.
But they're also supposed to be shaping society, the schools are.
We have time for one more question. Is there a student question? Yes, Jonathan.
Thank you all. Given the current disfavor for substantive due process and the Lochner problems mentioned, what's the advantage to grounding parental rights in the 14th Amendment instead of a kind of Yoder-focused First Amendment approach to parental rights in schools?
So I think the limits to a First Amendment approach is that not all parental rights claims are religious freedom claims. Now, for many parents, especially religious parents, they see their parental duties as explicitly religious duties. And so then free exercise rights would overlap with parental rights in a very significant number of cases. You can also make a very strong case that parental rights, at least in the educational arena, are speech rights. I mean, education is speech, teaching your children is speech. There's a great article by Philip Hamburger that actually makes the argument that the state-run schools' monopoly on public educational funding is an unconstitutional condition on free speech because it's privileging the state's preferred speech over parents' preferred speech. And so I think that's also an interesting argument. But again, I think there's something important in recognizing a distinct right of parents that protects that distinct authority that parents have that's prior to the state, and that can't be captured by the First Amendment jurisprudence.
So perhaps our speakers can speak to people afterwards if they've
Sure.
got a few minutes, but we have to call it quits there. Thank you so much.